Good afternoon. Welcome to Payentry's I guess every other week, bi-weekly webinar on a pertinent HR topic. My name is Cathy Graham, and I know some of you have visited the webinars before. I'm the VP of HR Services at Payentry, and I want to welcome you today and encourage you to attend the upcoming webinars that we have in July. There is a list of them that will be sent out in the next week to let you know what those are. Today, we're going to be talking about the Bermuda Triangle. And you don't normally talk about that in human resources, but when it comes to leaves of absence, it is pertinent. So the Bermuda Triangle, for those of you who aren't familiar with it, is an area out in the Atlantic Ocean off the coast of Florida where there's an unusually high number of ships and airplanes that have disappeared over the years without a trace. Kind of a spooky thing. We're going to talk today about ADA, FMLA, and workers' comp leaves and the interplay between the three laws because it is complicated and they overlap, and it can create some issues when you're trying to administer leaves of absence. And the reason we talk about this as being the Bermuda Triangle employment law is that it is complicated. Things do have a way of getting a little bit weird, and you have to pay attention to which rules you're following when you're in a particular law. Today, we're going to talk about the importance of recognizing that overlap and analyzing the interplay, and identify the important areas that you should be aware of. We're going to talk about the purpose of these three laws, the ones that we talked about. We're going to talk about which agency clarifies or governs each of those laws. We're going to talk about an example of an absence that involves all those leaves. So I'll give you an example that you can use going forward. And then we're going to do an overview, a little summary at the end. If at any time during the presentation you can't hear me, please let me know by going to the chat section. It is open for your questions, which we will answer at the end of the session. So during this webinar, please make sure that you jot down on the chat screen your questions for us to answer at the end. Okay, first of all, let's recognize and analyze the overlap or the interplay. The majority of absences that you deal with in a work environment are related to the employees or their family members, and that's the most common reason for a leave of absence. So when one of those illnesses happens, one, two, or all three laws can be involved. If you don't handle the leaves properly, then you could end up with a violation of a particular law, and that would result in penalties that might include you going back and paying for lost wages, back pay, reinstating someone to their job if they have you did not have a job for them when they came back from a leave of absence, retroactive benefits, which is a whole class of problems in itself, compensatory damages, and punitive damages. There's a direct review of the agencies that are involved in these laws that you as an employer are morally and ethically responsible to make sure that employees receive the protection and the benefits that they're allowed under these laws. So the courts look at it as your responsibility to make sure everybody gets what they're supposed to get. There are important areas of interplay or overlap between the three laws. One is which employers are covered, who's covered by what law. Another is who's eligible, which employees are eligible for which leaves. How long do the leaves have to be? What's the mandate? What kind of medical documentation are you allowed or should you get for each one of the leaves? Can you use restricted or light duty in returning people to work? And are you allowed to have a fitness to return to work certificate or a doctor's note saying they can return to their job? You also need to address what benefits are available to them while they're on a leave of absence and whether or not you are mandated to reinstate them to their current or their prior position. First of all, we're going to talk about the Americans with Disabilities Act. This prohibits your discrimination against qualified individuals with a disability or someone who has a record of a disability but may not be disabled right now, or they're regarded as having a disability. So that's kind of a broad statement. That could be someone with a dependent who has a disability, but it travels over into the employment setting by the individual's absence. The Family Medical Leave Act sets a minimum leave standard, or all the standards, for the birth or care of a newborn, and that does include adopted children too. Placement of a child for adoption, care for an immediate family member with a serious health condition, and cared for an injured service member, a member of the armed forces. The purposes of these laws, the workers' compensation laws are state specific. This one provides for payment of compensation and or rehabilitation for workplace injuries. And I know we all are very familiar with workers' compensation laws. They're different in every state. That's what makes them a little bit more cumbersome. So if you operate in different states, you may have a different set of laws in each of the states. Workers' comp laws are also supposed to minimize the employer liability, so that there's no open-ended lawsuit for these things, but sometimes it doesn't feel like it's minimized. I know when you have a large claim and it goes on, it can get pretty expensive. It also protects the employee against retaliation and protects their job. So who enforces which of these laws? The Americans with Disabilities Act is enforced by the EEOC, and that's where someone would file a charge if they feel that they have been discriminated against because of a disability. The Family Medical Leave Act is handled by the Department of Labor, and the Department of Labor also handles all the wage and hour laws and the child labor laws and a lot of the things that have to do with wages and employment. And workers' compensation laws, as I mentioned earlier, are governed by state individuals. The compensation commissions in each state determine what the rules are, how much someone would get paid if they were off, what the reimbursement rules are for medical claims and things of that nature. So each of these could, if someone is eligible for all three of these laws and something goes wrong, you could have all three agencies at your front door, which you never want to have happen. Another areas, well, let's just go over now the areas of overlap or interplay. First of all, who is required to be compliant with these laws? Under the ADA, if you have 15 or more employees for 20 weeks during the current or preceding calendar year, you are bound by all of the rules under the Americans with Disabilities Act. Under FMLA, employers with 50 or more employees in a 75-mile radius for at least 20 weeks during the current or preceding calendar year. So both of these have different levels. So if you have 50 employees, not only do you have to comply with the ADA, but you also have to comply with the FMLA rules. Workers' comp applies to almost every employer, even the very small ones. It also, again, goes back to the state requirements for that. As far as employee eligibility, who's eligible for which leaves? Under the ADA rules, the employee or applicant who is disabled and is qualified for the position and can perform the essential functions of the job with or without accommodations are eligible to be protected under this law. On FMLA, any employee who's worked for you for at least 12 months and 1,250 hours in the 12 months before the start of the leave um, are qualified to be eligible for this law. Employees have to report to a work site of 50 or more employees in a 75-mile radius, and that's a big deal, because if you have a salesperson out in the field, it's not where they live that deems whether they have 50 people in a 75-mile radius. It's where they report to. So it would probably be your corporate office or a district office for a salesperson that's out in the field. It would not be their home address. And then under workers' comp, it's any employee that incurs a work-related injury. As far as the length of leave of absence, under the ADA, there is no specific limit for how long the person can be out on their leave. So there's, because of that no specific limit, as long as it's not an undue hardship for the employer, you would have to leave them on that leave of absence. Under FMLA, the person is entitled to 12 weeks in a 12-month period. And then 26 weeks to care for an injured service member. Under workers' comp, again, like the ADA, there is no specific limit, but it does not look at the hardship issue for the employer. Medical documentation, what can you ask for? Well, under ADA, only information regarding that employee's disability that's job related can be requested to determine whether or not they can perform their job and whether or not any kind of an accommodation is needed. Under FMLA, you obviously can use the Department of Labor's medical certification form, but it can't exceed what's required on that form, so you can't ask for additional information. And under workers' comp, medical information that's related only to that person's on-the-job injury. You should not be able to, you should not require anything other than that. As far as restricted and light duty goes, under the the ADA, it is required if it's a reasonable accommodation that does not place undue hardship on the employer. So you would be required to offer restricted or light duty as a reasonable accommodation, as long as it's not something that goes above and beyond what you can actually afford to do. Under FMLA, you cannot require someone to return to work on a restricted or light duty job. And under workers' comp, you definitely should be offering light duty or restricted work because you want to eliminate as much time away from work as you can to reduce the impact of the claim. I know we want to get workers' comp and we want to get people that are on a leave of absence back to work as soon as possible, because the longer they stay out, the more chance there is that they're not going to come back to work. The fitness to return to work certification, this is a doctor's note that you would ask for the person to provide to prove that they are okay to come back and do their job. Under the ADA, Americans with Disabilities Act, it's permitted as long as the inquiry is necessary to determine if they can perform the essential functions of their job. And by essential functions of the job, I'm sure all of you are aware that the ADA has created a model job description that would contain what things are essential functions of that particular job and not peripheral responsibilities. Under FMLA, you can require only if that policy and practice applies to similar types of leaves that are not FMLA leaves. So if you have a medical leave of absence that employees who aren't entitled to FMLA can apply for, you would only be able to follow the requirements that you have for that other leave of absence. So your medical leaves and your FMLA leaves would be consistent in their approach to asking for this doctor's note. Under workers' comp, these are typically required for a return to work simply because you need to judge whether or not that person needs to be on restricted duty or light duty. What do you do with someone's benefits while they're on leave? And that comes up a lot. There are specific rules for ADA. You have to provide the same benefits as those you would provide to anyone on a non-ADA leave. So if someone takes the leave of absence, whether it's medical or not medical, what do you do with the benefits for those people? You have to follow the same rules for ADA leaves. Under FMLA, health coverage has to be continued at the same level as before the leave. Any other benefits that they have, you would follow whatever established policy you have for other leaves of absence, like dental and life and disability benefits, vacation, all of that. You have a policy for those other benefits when someone is on an FMLA leave, and it has to be consistent with anything else that you do for leaves of absence. Workers' comp, you're not required to continue their benefits unless it runs concurrently with an FMLA leave. You need to be consistent and follow the policy in place for other leaves of absence. I don't know how many times I've had HR people calling me and saying, well, there's an attorney and the attorney says that I can't cancel their benefits, and that's not true. There are no state workers' comp laws that require you to continue those benefits. What I advise them to do is just to be consistent, and if you have a policy in place for any other leaves of absence, follow that. You're also allowed to terminate them after a certain period of time, which you definitely should do, especially if they're on your benefit plan, because of the risk that you run if you don't take them off. So this is where I get a lot of questions, but you are not required to do that. The only leave that really requires it is FMLA. What about reinstatement to their job? Well, for ADA, requires reinstatement to the previous job unless doing so would create an undue hardship for the company. And let me tell you, the EEOC is not very lenient on what they consider an undue hardship on the employer. If it's going to cost you $1 million to bring this person back to take a job on the floor, then probably they're going to lean in your favor. But it has to be pretty significant in order to avoid this. FMLA does require that you reinstate the person to the same or an equivalent job, and there is no undue hardship exception. You have to bring them back. In workers' comp, there are no reinstatement rights under most state laws. Now check your state, and if you want me to do that for you, please just shoot me an email after this is over, and I'll look it up for you, but most states do not have any reinstatement rules. I would think California probably does, if there are any California employers on the line today, because they have one of everything, and so does Massachusetts. Here's an example. The employee's Alice, and she's an assembly line worker, full-time, employed for 3 years with perfect attendance. The company is ABC Manufacturing, and they have over 500 employees. Alice calls in sick for 3 days, complaining of extreme back pain. And then she calls in on the 4th day stating she was examined by a doctor, did some x-rays, and told her she needs to be on complete bed rest and that potentially she's going to need surgery. He did advise her she would be unable to work for an extended period of time. Alice then reports that the physician believes that her condition's caused by the work that she's doing for ABC Manufacturing. That's always a bad sign. So, is the employer covered? Yes, they are covered under and must comply with all 3 of these laws. What they're going to do from a practical standpoint is look at the workers' comp law first And we'll talk about that a little bit more because it is a workers' comp leave, and then they would look at FMLA and then ADA when the person is ready to come back. So you start with whatever kind of a leave it is. If this was not a work injury, then you would start with FMLA and then move on to ADA. Okay, employee eligibility, is she eligible? She may be protected under ADA depending on the severity of her condition. A lot of times this, a back condition can heal and they'll be back to work. So depending on the severity of it, at the end of her surgery and recovery, you would know whether or not this would be something that you would have to accommodate. So yes, she probably is protected under certain circumstances. FMLA, Alice has been there long enough. She's worked enough hours. She's eligible for FMLA leave, and she's also eligible for a workers' comp claim, filing a workers' comp claim. How long is she going to be out? Well, under ADA, we don't have to worry about ADA right now because ADA usually just functions as a reasonable accommodation rule. Leave as a reasonable accommodation is not necessary right now since Alice is covered under FMLA and is going to be out. So the accommodation would only come into play if she exceeds the FMLA leave. At that point in time, she could request additional leave as a reasonable accommodation. So that would be, for the most part, where that ADA would come into play, is at the end of the FMLA leave. Alice obviously is entitled to 12 weeks of leave. And if the conditions deemed work-related, if her claim does go through, the workers' comp leave runs concurrently with FMLA leave. So you would put this person, you would file the workers' comp claim, but at the same time, you're going to put Alice on an FMLA leave, which is a protected leave, and offers her the benefits during that time. So these two, FMLA and workers' comp, run concurrently if the person has the requirements or the eligibility to be covered by FMLA. The medical documentation that you require, it would not require anything for ADA right now because the end of the FMLA leave hasn't occurred. You can require Alice to complete FMLA medical certification and should do that, claiming that time as FMLA leave. And obviously, medical documentation is required by the insurance company for a workers' comp claim. Restricted or light duty under ADA, that doesn't become a requirement or even something you need to worry about until the person exhausts their FMLA leave and wants to return to work or wants to return to work in some capacity. Under FMLA, you cannot require light duty while on an FMLA leave. So if they have FMLA leave, they're out, off work. Light duty under workers' comp should be offered to Alice. We spoke a little bit earlier about the fact that you want to shorten that claim as much as you can. So get them back to work. Your insurance carrier will probably be on top of you to do that. And whatever you have to get the person to do, whether it's sitting at the front desk, greeting someone, greeting the people that come in, whatever it is, get them back to work. The return to work certification of the doctor's note is not required under ADA until the person is able to return to work. Obviously, they're out on an ADA leave. And then Alice can be required to produce doctor's note saying that they can return to work in full capacity. Under workers' comp, it may be required. And usually is. I've always seen someone being released back to work through a doctor's certification. What about their benefits while they're on leave? We talked a little bit about that. Under ADA, you're not required to continue their benefits unless you do so for other under other leaves of absence, not FMLA, but the other leaves of absence, like a non-FMLA medical leave or a personal leave of absence. Treat them all the same. Under FMLA, her health benefits would be continued at the same level as before her leave. That means that you would charge her the amount that you would have taken out of her paycheck if she were an active employee. Other benefits are continued following the policy for all similar non-FMLA leaves. On the benefits and, well, how do you collect that money? If the person is going out and this leave is unpaid, you have no way to recover it from the paycheck. So you actually have three options. That's not on the screen, but you have three options. You can have them prepay. You can have them pay as they go by sending you a check each month, which would be on an after-tax basis, or you can have them catch up their payments when they come back. That's a little dangerous because they may not come back. So depending on your level of risk-taking, you could decide how you want to collect. Most employers collect as they go or upfront. On workers' comp, you're not required to continue their benefits. Follow your other leaves, though, not ADA or FMLA, but your non-FMLA medical leaves and your personal leaves of absence. What do you do with the benefits when someone's on one of those leaves? Apply that to workers' compensation and you will never have a problem. Just be consistent. Consistency is a key word in human resources, and as long as you have the same practice for different medical leaves that are not regulated by law, then you are fine to apply them in most cases. And what about reinstatement? Well, under ADA, Alice has to be reinstated to her previous job unless it creates an undue hardship for the employer. And in most cases, the EEOC requires that you put out a pretty good deal of effort to get that person back to work. Under FMLA, she has to be given her same job or an equivalent job, which means the same level position if she was a manager or if she was worked a certain shift. You have to give her back that title and that shift or an equivalent job, which would pretty much mean that she'd be working the same shift and at the same level and same pay. And under workers' comp, there's no requirement for reinstatement, and that is under most state laws. I don't know of one that requires reinstatement, but I can help you research that if you need it. Okay, in summary, the three laws each have a different purpose, and obviously ADA, the Americans with Disability Act, protects individuals against discrimination. FMLA establishes minimum leave standards, and it also tells you things like what to do with their benefits while they're gone, and it tells you, other than how long they need to be out, what type of communication you have with them, what kind of forms they have to send, and what kind of things qualify for that leave. Workers' comp laws provide for the payment of wages for someone who has an injury that takes them away from work, and rehab on the other end. It does also provide for medical expenses, and overall controls the employer maximum liability. Employers need to recognize that there is crossover in all of these leaves of absence. And whenever a medical leave occurs, more than one law might be involved. Start out with workers' comp. If it's not a work comp injury, then see if the person's eligible for FMLA. And if not, you have your regular leaves of absence for medical. Not until the person is required to come back or wants to return to work do you even have to consider the ADA laws. So it's the last to be considered because it is the return to work in a different capacity potentially or with assistance. Your legal responsibilities boil down to ethical and moral responsibilities that all of the agencies feel that you have as an employer. and they think that you have all the obligations in the world to bring those people back to work and to help them through that period of time away from work. This is the end of our formal webinar. Does anyone have any questions? If you do, the chat is open for you to type in the question that you have, or you can email me after the session is over, and I'll be happy to answer you if you have a specific situation that you want to discuss. That's why I'm here. Payentry hired me so that I could help you with your HR questions, and feel free to call me or email me at any time. I love talking to the clients and helping you solve your problems if I can. I'm not a payroll person, but I am an HR person, and I can help with anything that the payroll department can't help you with. Looks like there are no questions, so we will end today's session, and I look forward to seeing you. I guess I can't really see you, but in my mind, I see you. I'll see you virtually in July. Thank you.